Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, as the title suggests, we're talking about K-1 Fiance visas and specifically the issue of marijuana. Now, marijuana, cannabis, if you will, has been of increasing interest and is increasingly newsworthy in the United States as a result of various jurisdictions either decriminalizing marijuana, fully legalizing marijuana, especially recreational marijuana. The state of Colorado comes to mind with respect to that, or jurisdictions like California where medical marijuana is legal. Now, you have to keep in mind, federal law remains the same as it has been for quite some time, which basically stipulates that marijuana is considered a highly regulated drug and illegal possession or usage of it is considered a violation of federal law. Notwithstanding the fact that, again, it's a federal system in the United States, states may allow it, but the feds may not. This can have tremendous ramifications in an immigration context, which I'll get to here in a moment. But another thing to keep in mind is this is of increasing concern, in my opinion, to those who are seeking K-1 Fiance visas from here in the Kingdom of Thailand, because Thailand has recently promulgated legislation which will relax regulation of certain types of cannabis and cannabis products. Most notably, Thailand is also rolling out a medical marijuana regime, which will have wide-ranging ramifications down the road, and we've done other videos on this channel specifically on that topic. But the thing to take away from this video today is how does marijuana interplay with the immigration process? Well, first of all, keep a couple of things in mind. An immigrant is subject to U.S. federal as well as state law. And for that reason, the immigrant in question needs to be aware that marijuana and usage thereof, possession thereof, etc., remains a legal ground of inadmissibility to the United States. It's not conviction alone that rises to the threshold of inadmissibility. And what I mean to say by this is someone who's admitted, for example, in open court to having possessed a certain amount of marijuana or used marijuana could have inadmissibility ramifications brought against them because the mere act of possession or the mere act of usage may rise to the level of being a legal ground of inadmissibility, notwithstanding the fact that an individual may have never been tried and convicted of an offense involving marijuana or cannabis. The other thing to keep in mind is those that apply for visas abroad, specifically, for example, here in Bangkok, there's a medical examination requirement which is undertaken by a civil surgeon that is accredited by the embassy here in Thailand. And that civil surgeon specifically is tasked with ascertaining whether or not the individual seeking admission to the United States has a drug problem. And for this reason, experimentation, or should I say usage of marijuana, could be a serious problem for those who are applying abroad, specifically from here in Thailand, wherein in the future we may see a regime where marijuana and cannabis products may be perfectly legal in Thailand, but under U.S. federal law may remain not only illegal, but it also may remain a legal ground of inadmissibility pursuant to the Immigration and Nationality Act. I could even see, in theory, it's a bit far-fetched, but a circumstance wherein maybe the federal law changes, but the immigration law hasn't changed, and it remains a legal ground of inadmissibility, I would presume, for a fairly short period of time, while the laws are being changed on immigration with respect to marijuana. The point of this video, if you're looking to go to the United States and immigrate there, or if you're in the United States as an immigrant in K status or adjusting your status, you really need to seriously consider, do I want to deal with the adverse consequences of ingesting cannabis or marijuana when those adverse consequences could result in deportation and a bar from the United States in my proceedings, in whatever situation I'm in. So in the K-1 scenario, do I really want to be dabbling in marijuana here in Thailand when I have a pending K-1 application? And if you're in the United States waiting for adjustment of status, or even in green card status waiting for example, a lift of conditions or maybe even a naturalization to process, do you really want to deal or have to deal with the adverse consequences of marijuana in your immigration case in my opinion, frankly, it's probably prudent to just stay away from the matter altogether, unless you're a U.S. citizen. And even then, there's still a lot of ambiguity with respect to the interplay between federal and state laws on the issue of marijuana.